Hello, and welcome to our panel titled 20 Years on Humanitarian Action in the Era of Counterterrorism. My name is Ahmed Al-Musa from the Columbia Global Center in Amman, and I thank you all for joining us today. Our event today is the third in a series of 4 panels that we have been hosting with the Program of Forced Migration and Health on the 20th anniversary of the Iraq invasion. This series has been focusing on the enduring impact of the Iraq War on both the humanitarian and geopolitical landscape. To recap the topics that we have already covered in this series, on April 26, we held our inaugural event with guest speakers Fabrizio Carboni, Professor Les Roberts, and Sahar Mohamedou. They analyzed the impact of the Humanitarian Action Framework adopted by the United States in 2001, which linked US military and strategic objectives with the activities of humanitarian and development NGOs. This framework has imposed limitations on humanitarian agencies and has had repercussions on the delivery of humanitarian aid. The panelists offered insightful perspectives that enhanced our comprehension of the roles played by humanitarian organizations in conflict settings. They also discussed strategies to enhance their effectiveness while upholding core principles of neutrality and impartiality. Our second event, which was held on June 20th, brought together a panel of Iraqi experts that included Dr. Dina Asfandiari, Professor Shamiran Mako, and Dr. Rinad Mansour. These experts provided thought-provoking insights as they assisted us in unpacking the far-reaching geopolitical ramifications of the Iraq War, which have had a direct impact on the landscape of Iraqi politics, governance, and civil society. The panelists delved into the impact of the post-2003 de-Baathification strategy and subsequent adoption of ethno-sectarianism on Iraq's political landscape. They discuss how these factors have contributed to a recurring cycle of violence. Furthermore, they explore the emergence of collective solidarities aimed at addressing grievances and challenging the power-sharing agreements that have resulted in the current political deadlock and the gradual erosion of the state in Iraq. Additionally, the panelists examined the evolving regional dynamics and power balance since 2003, which has given rise to new decision-making centers in the Middle East region. These centers have gained greater independence in shaping their foreign policies, and the implications of this shift on Iraq's current political situation were also considered. Today, our third panel in the series will look at how the 9/11 attacks and subsequent invasion of Afghanistan and Iraq ushered in global and national counterterrorism measures. These measures have placed restrictions on whom humanitarian actors can work with, thereby jeopardizing the principles of impartial aid delivery and leaving vulnerable populations without support. Our panelists today will engage in a discussion centered on how the counterterrorism framework is influencing the dynamics of humanitarian aid and the provision of services within this context. They will examine how these measures have created limitations on the groups and individuals that humanitarian agencies can access and assist. We'd like to also remind our audience to mark their calendars for the fourth and final panel in this series, scheduled for November 9th. In this upcoming hybrid event, we will explore how technology is reshaping both the nature of warfare and humanitarian operations. We will investigate the growing role of technology in disrupting humanitarian systems, as well as the vulnerabilities it creates for people affected by this conflict. Now, I would like to extend a warm welcome to our panelists, Yelena Page, Emma O'Leary, and Professor Mahmoud Mohamedou, and introduce Mohamed Zard, who is leading the series and will be moderating today's panel discussion. Dr. Zard is the director of the Program of Forced Migration and Health and Associate Professor of Population and Family Health at Columbia University. She will be introducing our esteemed panelists and lay out the framework for what we'll be discussing today. Thank you all. Over to you, Mohamed.
Thanks so much, Ahmed, and welcome everyone to today's panel. So as we continue in this series to explore the ongoing impacts of the Iraq War 20 years on and its implications for humanitarian action, we couldn't ignore the expansive legal and policy regime that has been created over the last 2 decades around the efforts to combat terrorism. And while we cannot place today's counterterrorism framework solely at the feet of the 2003 Iraq invasion, it was one of the catalysts that accelerated its development alongside the attacks of September 11th, 2001 and the war in Afghanistan. So this framework includes international as well as national laws, regulations, and policies that restrict and sanction support to groups and individuals that are designated as terrorist entities. And taken together, these create a complex maze that humanitarian actors have to navigate that both directly and indirectly impact the neutral, independent, and impartial delivery of aid in certain contexts and to certain populations. So, for example, when non-state actors are designated as terrorist groups, states are usually required to freeze their assets and funds and ensure that no funds are made available either directly or indirectly for their benefit or by their nationals or persons within a state's territory. So in those situations where the non-state actor controls or has significant presence in areas with populations in need of assistance, so think, for example, the al-Nusra Front in northwestern Syria, Boko Haram in northern Nigeria, and Islamic State in parts of Yemen, the Sahel, and eastern Afghanistan, this kind of provision can directly impact humanitarian activities. It can deter donors from making funds available to humanitarian actors in these territories, or it can lead humanitarian organizations themselves to restrict their activities because they fear violating these sanctions. Further raising the stakes, in 2019, the Security Council adopted Resolution 2462 to counter the financing of terrorism. And that resolution requires states to criminalize economic support to those listed individuals and entities for any purpose, even where there is no link to terrorist acts. And there are, of course, knock-on effects that come from this approach. So the International Committee of the Red Cross, or ICRC, for example, has warned of a chilling effect where some humanitarian organizations have self-regulated beyond what is legally required. Financial intermediaries, at least some of them, have delayed or refused to facilitate transactions with humanitarian organizations that operate in high-risk areas in a process that is sometimes referred to as financial de-risking. And some donors have, of course, restricted humanitarian organizations from providing services in areas controlled by sanctioned entities. And for others, the increased vetting and compliance that is required for local partners to receive funds can ultimately sort of undermine trust and complicate stated commitments to localizing aid delivery. So while in recent years we've seen humanitarian carve-outs or exceptions that have sought to try and mitigate these impacts, there remain real and ongoing challenges to humanitarian operations in some of these hard-to-reach areas where civilian populations are likely experiencing significant need. How humanitarian organizations navigate this complex terrain and operationalize the principle of impartiality in particular, so that populations are assisted according to greatest need, remains a distinct challenge. So, helping us to navigate this very complicated terrain, we are delighted to welcome a distinguished panel today. Our first speaker will be Jelena Page, who is a non-residential senior fellow at the Lieber Institute for Law and War at the West Point Military Academy and the Lieber Scholar for 2023 at the Institute. Ms. Page was formerly a senior legal advisor with the legal division of the International Committee of the Red Cross in Geneva, and she has been a practitioner and scholar of international humanitarian law for over 25 years. She headed the ICRC's legal response to the so-called war on terror, and subsequently led the ICRC's effort to encourage states to improve compliance with IHL. She has written and published extensively on various issues of IHL, human rights, and criminal law, and is a leading authority in this field, and we're just delighted to have her with us. In her remarks today, Jelena will help flesh out what is this counterterrorism legal framework and how it's impacting IHL and humanitarian action. Our second speaker will be Emma O'Leary, who is head of the Norwegian Refugee Council's Humanitarian Policy Unit currently seconded to work on a temporary assignment with the Interagency Standing Committee. She is a subject matter expert on the impact of counterterrorism measures and sanctions on principled humanitarian action. She has worked for the NRC in field-based positions and policy positions since 2016 and has led the organization's work on this issue since 2018. She's carried out research and workshops on the topic in a wide variety of contexts, including Afghanistan, Senegal, Nigeria, Palestine, Somalia, and Yemen. And in her remarks, Emma will tease out how this counterterrorism framework is making itself felt in humanitarian operations on the ground. And our final speaker is Mohamed Mohamedou, who is Professor of International History and Politics and Deputy Director of the Geneva Graduate Institute, where he's also Director of Executive Education. He is a visiting professor at Sciences Po Paris and was previously Associate Director of the Program on Humanitarian Policy and Conflict Research at Harvard University. He is the author, notably, of a trilogy on the post-9/11 era, examining the geopolitical implications of the September 11 terrorist attacks and their impact on international relations and transnational forms of political violence. Professor Mohamedou's research focuses on political violence, warfare, state building, transitions to democracy, and the history of racism. And he is the recipient of the 2021 International Studies Association Distinguished Award. In his remarks today, he will reflect on how the counterterrorism framework is really reshaping the boundaries of humanitarian action and the populations that are served by it and excluded from it. We're really delighted to have him with us and all three speakers. Our panelists will each speak for about 10 minutes, and then hopefully we will have a chance for a little Q&A with the audience. So please do be putting your questions in the Q&A box, and we will get to them. But without further ado, over to you, Yelena.
Thank you very much, Monette, for that very kind introduction. Hello to my panelists and hello to everyone who's listening to us, wherever they may be, including in the Amman part of the audience. So I'm going to talk a little bit about the legal framework related to humanitarian action and counterterrorism, and I'm going to jump right in by saying that the legal framework for humanitarian action in armed conflict, and I will only be speaking about armed conflict, is provided by international humanitarian law, also known as the law of armed conflict, or rarely the law of war. Now, this body of rules applies only when armed conflict exists, whether international, that between states, or non-international, that between states and non-state armed groups, or between such groups themselves. Therefore, we talk about international and non-international conflict as being regulated by IHL. One thing to know about IHL, which explains partly the blurring and the mess, if I may put it that way, that has happened since 9/11 in particular, is that while violence, meaning the taking of life, destruction of objects, etc., is always the same, the legal regimes and the context in which it happens is different. So humanitarian law, meaning the law of war, aims to regulate violence in a way that is unique to this reality. The purpose of war is to overcome the enemy, leaving aside what I think of war as such. And therefore, IHL is the body of rules that allows violence against military objectives and combatants, and prohibits violence against civilians and civilian objects. It's a balance between necessity and humanity, and its aim on the whole is to have a protective function. When something is called a terrorist act, it is always prohibited under domestic law, under any possible regime, and I'll come to that in a minute. In terms of humanitarian action, IHL provides the legal basis for it, as I've mentioned, and the basic rule is that it is the primary responsibility of the parties to a conflict to provide for the needs of the populations under their control or territory. Now, there is a difference between the rules governing international and non-international armed conflict, and I'm talking about international armed conflict now. humanitarian organizations under IHL very clearly have the right to offer their services to the parties to a conflict. And the service offer is actually very clearly related to organizations that are impartial and humanitarian. Those are the two conditions that IHL spells out for a valid offer of services. It is considered, although it's not written in the treaties themselves, that an offer of services, cannot be arbitrarily denied. What is arbitrarily denial of an offer is a whole different issue, which I don't unfortunately have time to get into right now. And in IHL treaties, the texts mainly mention an offer of services by the International Committee of the Red Cross and any other impartial humanitarian organization. The provisions on humanitarian operations are quite varied. I mean, there are quite a few of them in international armed conflict. I just want to raise the issue because it has arisen, and it is the whole issue of consent to humanitarian operations by states or not. I submit, based on very explicit treaty language, that consent is required in international armed conflict, regardless of the type of situation involved, because the treaties actually say so, and the particular article relating to offers of services by the ICRC and other humanitarian organizations mentions consent. I will just close here by saying, in reality, we can get into the consent discussion if necessary. In reality, it is impossible for international, local, or any organization to barge into a country or into a situation without, in fact, having arranged that engagement with the parties to the conflict. Now, the counterterrorism framework, we have a before 9/11 and after 9/11, in fact. Before 9/11, there was a series of treaties on terrorist bombing, financing, hijacking, hostage-taking that were adopted within the framework of the United Nations with very wide, I would say, ratification, meaning acceptance. And most of those treaties had exclusion clauses for situations of conflict. Therefore, it was provided essentially that where an armed conflict situation is happening, acts under that treaty that are otherwise called terrorists will not be governed by those treaties, but will be governed only by humanitarian law. Another thing to note, which is really important, is that there is no comprehensive definition of terrorism, which has made the blurring between IHL and terrorism unbelievably expansive. And there was an effort, and still is on the table, to negotiate a comprehensive convention on terrorism, which has a definition, but it ran into trouble years ago. There's a stalemate going on. And one of the reasons that has happened is because precisely of the interface between IHL and the comprehensive convention's definition. So the bottom line, the thing that's holding up, and it's relevant, I think we're linked to what Mohamed said, is that under the convention, there are a group of states who do not want to exclude the activities of non-state armed groups from being called terrorists if they happen in war. Therefore, even lawful attacks that would take place under IHL against military objectives, for example, by non-state armed groups against state objectives, would be considered terrorist acts, which is not the case under IHL. And then there's another group of states which essentially want the activities of non-state groups also to be excluded to make a clean break between terrorism and IHL regulation. And that's one of the reasons that the draft comprehensive convention hasn't moved. And then came 9/11, and already in September 2001, the Security Council adopted something called Resolution 1373 as a legally binding guidance to member states of the UN, and it related to to terrorism. It was the first in a series of UN Security Council resolutions under Chapter 7 of the UN Charter, which means that it's legally binding and that all states must implement it. And that was really the beginning of the chilling effect on the work of humanitarian organizations. So it performs a couple of goals, but one of those things that it says, and this is what really impacted and was the beginning of the impact of counterterrorism on humanitarian action, is it specifically says that states must, and I'm going to read it here, prohibit their nationals or any persons or entities, etc., from making funds, financial assets, economic resources, or financial or other related services directly or indirectly for the benefit of persons involved in terrorism and entities, and that they must refrain from providing any form of support, active or passive, to such persons or entities. Now, none of these terms, support services, related services, etc., were defined, and all of this was essentially left to states. And so that's when the impact, which was of course gradual because states had to implement this particular paragraph and the other paras in their domestic legislation, that's when the impact on humanitarian action slowly but surely started. And I'm not going to talk about the specific impacts because Emma O'Leary is really the expert on this and has written wonderful articles. The one in the International Review of the Red Cross and Red Crescent is fantastic, I thought. But I will just say the following. The fact is that the sanctions regimes under these resolutions and then the designations of terrorist groups or entities on lists simply meant that the contact, starting from practically contact of humanitarian organizations with non-state armed groups, particularly those controlling or having a substantial presence in territories, became extremely difficult. The donors became very skittish. A lot of organizations became extremely skittish, and so did sort of third-party, if you like, actors such as banks, commodities dealers, insurers, etc. One thing to note, and Mohamed, please interrupt me when I should stop. 1 more minute. One thing to note is that 1 more minute only. Okay. One thing to note is that there has been an evolution since the resolution 1373 was adopted, and that thanks to the lobbying of, first of all, the obvious effects of counterterrorism measures on humanitarian action, the lobbying of NGOs and humanitarian, and some governments who were friendly, in December last year, the Security Council, acting again under Chapter 7 of the UN Charter, meaning adopted a legally binding resolution, to put it very crudely, reversing some of the effects that started with Resolution 1373. So it in fact took 21 years to reverse the worst effects of the 1373 resolution that really constrained the work of humanitarian organizations. The resolution has an incredibly long, very convoluted paragraph of like 15, 20 lines with no full stops at all. And two things to note, and it's a very welcome development because awareness has finally arrived of the problems that were caused. But it applies only to sanctions adopted by the Security Council, and therefore does not necessarily impact, domestic sanctions or those at the regional level or terrorist lists for that matter. And of course, just like it took years for the first resolution to be implemented in domestic law, it is very likely that the implementation of this resolution is going to take a long time, and it was going to be left up to states to determine how and whether they adopt, measures, if you like, delisting, reversing the humanitarian, the inclusion of humanitarian action within the counterterrorism measure system. So it remains to be seen what will happen. We can only hope for the best. And as I have exceeded my time, I will stop here and look forward to any questions you may have. Thank you.
Thanks so much, Jelena. No, thanks for laying that out for us. And I think I'm going to move swiftly to Emma.
Thanks very much, Monette. Hello to everyone online. It's lovely actually to follow Jelena, because I am not a lawyer by trade. My focus in relation to this work is very much on the operational impacts and how we can operationally address some of the risks and challenges that have arisen because of the issues we're talking about today. As Monette said, I usually work for the Norwegian Refugee Council. I should say I'm here in a personal capacity today. So I'll start very briefly by framing the issue. I want to look a little bit at how some of the instruments we're talking about today intersect with humanitarian action. I'll then look at some of the impacts that we face in the course of carrying out our work. And then I want to talk a little bit about what we're actually trying to do about this and how we're trying to address some of these challenges as well, because there's a lot of work going on there too. So, I mean, as has been mentioned by both Monette and Jelena, certainly since 9/11, we've seen a massive proliferation of measures trying to prevent funds or other types of assets from getting to individuals or groups that are targeted by counterterrorism measures or sanctions. And for humanitarians, we find it helpful generally to look at this from three levels. First of all, the international level, so the Security Council, it brings in measures that criminalize or tell states basically, you must criminalize the provision of funds or other types of support to these groups or individuals, or sanctions groups or individuals, making it illegal to provide this kind of support to them. Then we have member states. They must transpose these Security Council decisions domestically. And of course, as Jelena mentioned, crucially, we have no definition actually of terrorism at Security Council level. So this means states, of course, go ahead and will implement these measures domestically in a way that very much is in line with their own sort of political and security aims. And on top of that, of course, they can develop their own domestic measures that relate to sanctions and counterterrorism measures as well. And of course, we've seen, significantly the US has done this, as have the UK and others as well. And then finally, and crucially really for humanitarian actors, many of us are dependent on institutional donors, on governments, essentially, to fund our operations. And when we received funds from them, we generally have to sign grant agreements. In some cases, donors will try to reflect counterterrorism measures and sanctions in those grant agreements as well. This can be particularly problematic for humanitarian organizations, because it sometimes means we're actually exposed and required to comply to sanctions and counterterrorism measures that we wouldn't otherwise have a legal link to. And this, of course, provides its own challenges. And in some cases, I should say, in the past, this is thankfully a trend that's reversing somewhat now, but we see governments introducing language in their grant agreements that's actually stronger and more stringent than what is in their domestic legal framework. So how does this impact humanitarians? How does it impact humanitarian action? Well, of course, we as humanitarians are often working in these environments where groups or individuals that are impacted or targeted by counterterrorism measures or sanctions are often in control of areas that we need to access. We're trying to access these areas for the purposes of providing humanitarian assistance. This requires often engagement with these groups in several different ways, counterterrorism measures and sanctions can pose challenges to that. These groups in many environments position themselves as authorities in their areas of operation. They can impose taxes. They can ask for per diems to be paid should they attend workshops and other meetings. And they can engage in other activities that might be considered normal for an authority, but could pose particular challenges for humanitarians vis-a-vis our exposure to counterterrorism measures and sanctions. In addition to this, they can of course mean that donors, our institutional donors, the governments again that we're often relying on to support our work, it can mean they're less willing to provide us with funds to operate in certain environments where they believe there's a high risk of terrorist activity. It can also mean that we can struggle to access crucial services, support services like those provided by financial institutions as well. So at a very practical level, often when we talk to governments and others about this issue, we're often asked, okay, but what are the real examples? Where is this really coming up as an issue for you? And I mean, we can go way back in time to start drawing those out. I think one of the most well-known cases in relation to this, but still one of the most striking, is Holder versus Humanitarian Law Project, which happened in the US under the Obama administration when a small US-based NGO called the Humanitarian Law Project ended up in a court case. And ultimately, the US Supreme Court decided that the provision of something as innocuous and potentially beneficial, actually, as training on international humanitarian law to designated groups could be considered material support to terrorism. So that is, one of the kind of most striking examples, I think. Another and more recent example comes from the UK's Counterterrorism and Border Security Bill. So this was introduced maybe 2019, I think. And the bill was quite unusual in that it was, as far as we knew at the time, only the second ever attempt to do this, but it was an attempt by a government to make it illegal to travel to areas where terrorist activity was believed to be happening. Essentially, it allowed the government to designate areas instead of groups. And of course, the bill was introduced with no exemption for humanitarian actors. After intense lobbying by humanitarians, eventually an exemption was introduced. If it hadn't been introduced, we would have been running the risk of having staff being investigated and potentially facing up to 10 years in prison for traveling to these areas in the course of their normal work, much of which actually was funded by the UK government. So a real lack of joined up thinking in some of these measures as well. Turning a bit more to kind of our areas of operation, Mohamed mentioned in her opening remarks Nigeria, and I think this is the Sahel, I would add, is also more broadly an area that's posing particular challenges in relation to this this file at the moment. The Nigerian government has been very strong in terms of its rhetoric around the fight against terrorism. And that has manifested in a way that's posed real challenges to humanitarian operations, particularly in the northeast of the country, where Boko Haram is particularly active. Essentially, humanitarians are prevented from operating in areas that are outside of government control. We don't know precisely how many people are in those areas, but estimates have been at around 3 million. So this is millions of people who are in need of humanitarian assistance and are not receiving it because of restrictions imposed by the government. And for those who try to engage with the government on this, to try to advocate for better humanitarian access, the rhetoric is really people who are operating in those areas are providing support to terrorists. So really the provision of humanitarian assistance is being conflated with support to terrorism. And now not only does this mean that people in need of assistance are not receiving that assistance, it also has the further effect, I suppose, of impacting how these groups perceive humanitarians. So to be able to operate in environments where you have non-state armed groups or any authority really, we rely on acceptance by those authorities. They need to know what we're doing, how we're doing it. There has to be a level of trust and knowledge about our operations there. And because we're not engaging with these groups, they automatically see us as not impartial, as siding with a party to the conflict, and therefore as a legitimate target. We saw a couple of years ago, ISWAP release a statement saying that humanitarians in the Sahel were considered legitimate targets. And this is, obviously deeply concerning, but it's also unsurprising because we haven't been able to engage with these groups. So how are they going to be able to understand what we're trying to do, how we're trying to do it? How are we going to be able to build the necessary acceptance in an environment like that? And finally, also with an eye on time, I did want to mention as well the issues in relation to banking, because it's, possibly one of the less exciting, impacts, but it's an extremely important one. To operate in these environments, we must be able to transfer money to pay our staff, pay our contractors, our suppliers. we are finding that banks are increasingly risk averse. They're increasingly concerned about falling foul of sanctions and counterterrorism measures. They're worried about their ability to access international markets should they get in trouble with a global regulatory body like the Financial Action Task Force. And as a result of this, they are being very careful about for whom and to where they're transferring money. It is becoming increasingly difficult for us as humanitarians to get our funds where they need to go. And that is, in conflict affected environments, that means, where we can't potentially pay staff, we can't potentially pay suppliers and so on. It means not only that we're going to face challenges getting our assistance out, it also potentially means safety and security risks as well. And this is a very pressing issue, and it essentially means that at some point down the line, if we don't address it, we are going to be faced with a situation where banks are really dictating where we can operate. So that is another key impact too. I briefly want to touch, before handing back the floor, on the issue of what we're doing about this and how we're trying to address these challenges. NRC, we've been working on this issue since before 2010, and I think for a long time, it's fair to say it was really ourselves in the Norwegian Refugee Council and ICRC as lonely voices working on this issue. It was not a topic that garnered a lot of attention within the broader humanitarian community, and it wasn't one that was well understood, I think, by states and other stakeholders more broadly. That has changed a lot in recent years, largely because the level of restrictions that we're seeing have gotten too big to be ignored, and our colleagues in humanitarian organizations are paying a lot more attention. We have seen some positive developments. We've seen, very dramatically in December last year, the introduction of Resolution 2664, which introduces a cross-cutting humanitarian exemption in Security Council sanctions in the asset freezes elements, which is the one that really concerns us. But we have this is a really, really positive development, and actually one that I think 10 years ago we would never have expected to happen. But we have a long road to go beyond this. We all recognize that states are well within their rights to impose these measures. We're not asking them to stop imposing them. What we're asking is that they make sure safeguards are in place so that our work isn't inadvertently criminalized in the process. Thank you.
Thank you so much, Emma. So I am conscious of time. I'm going to move very swiftly on, but just a reminder, we'll be able to take a question or two, so please put them in the box if you have a burning question. But now for some historical context and to, I guess, help us think through the implications of some of these measures. Over to you, Professor Mahmoud.
Thank you very much, Monette. My greetings to everyone. My thanks to my colleagues. Ever so briefly, and conscious of time as well, so that we have a little bit of exchange with the audience. I'll make 3 points against the background of everything that's been presented. None of this happens without context, and none of this remains without consequences, of course, as we can imagine. And I want to speak here more from a political historian perspective, as Monette kindly indicated. The 3 points I'll make are, one, about the fact that, in effect, a lot of this started a little bit before 9/11. The whole set of dynamics that we see in play did accelerate. 9/11 does change everything in many ways, but there are a lot of dynamics at play before that. The second point will be about the 9/11 plus, everything that followed, particularly Iraq and Afghanistan, but also Sahel, as was mentioned, and other places, East Africa, etc. Afghanistan, obviously. All of that also essentially has to be understood as a major step back historically. And a lot of this history and the violation has been a little bit forgotten, I think, by the current generation. Most of us who lived through this do remember a lot of zeitgeist, and this isn't the nature of historical facts being lost. And we need to be aware of what is the context of what actually happened. And my final point will be about the consequences of the legacy of the 9/11 plus, sort of the long shadow of all of this. So on the first point, in the 90s, and mostly looking at the violations that concern essentially Muslims and brown and Black people more generally, in the consequences of the racialization of this conflict, we see a lot of these dynamics emerging. The United States goes into the Middle East for the very first time militarily with the 1990-91 Gulf War. This is really a sea change. We see a lot of sort of dynamics that are born after that. Al-Qaeda itself is formed after that. We have a lot of conflicts that take place during this decade, specifically on that front. In 1996, the CIA creates its anti-Bin Laden unit. 98, you could say that the first shots of the 9/11 quote-unquote war are really shot when the United States, when the Al-Qaeda targets US embassies in Tanzania and Kenya, and then the United States within 48 hours reacts by bombing AQ camps in Afghanistan. USS Cole attacked, and so on and so forth. This is also the decade of a lot of interventionism that we see during that decade, all the way to Kosovo, but previously in other parts. And there's a certain kind of release in that discussion of the need to reposition the so-called civ-mil conversation that starts being discussed. The concepts as do not harm, the concept of human security. I'm blending both human rights and humanitarian, but my colleague spoke clearly about the framework and the operational aspect on this. And so we really have a lot of this up in the air. I'm struck by one Hollywood reference. There's a forgotten 1998 film entitled The Siege, in which you see that after a series of attacks on New York, there's essentially measures that are implemented, state of siege, but also violations, torture of Muslims, and in fact, sort of a concentration camp built on the other side of Manhattan. And you see in that whole divide between Denzel Washington symbolizing sort of the liberal aspect and pushing back the conservative Bruce Willis, and I think it was Annette Bening stuck as the symbolic US in the middle, everything that we will see happen 3 years later with 9/11. So a lot of this is already up in the air quite significantly. With 9/11, all of this is ushered into the next phase, and we see major violations that are very much put in action. The neocon plan, which has, of course, been up in the air itself before 9/11, is put into motion. The resolutions are essentially enabling, and we spoke about Yelena spoke about the vagueness of the specific language as regards terrorism per se, which is also part of the possibility of improvisation that the Bush administration had, the lack of organization around that, at least in terms of consensus internationally. There's quite a lot of dimensions that are, of course, regulated as dimensions of the problem, but not the whole of it. And so there's always the political understanding that remains. Plus, I would add to that, without going into the legal discussion, the fact that Al-Qaeda also, as a non-state actor, muddied the picture. It became a little bit more complex to be able to speak of war when you had an entity that technically was not able to wage war, as IHL is historically been understood in that sense. But above and beyond that, we saw major acts of torture, violations. This is a bit forgotten, as I said, but the violations were quite nasty. This is not a pretty story. We saw essentially secret prisons, ghost prisoners, torture, rendition, not just in the United States, of course. This was a global activity from the jails of Pervez Musharraf in Pakistan to Syria, renditioning for the United States, unbelievable sort of allies that you see by way of Sahel, going into all manifest kind of dimensions of this, but also secret ones with prisons that were in the heart of Europe, as released, reported by one Swiss parliamentarian at the time, Dick Marty. Not much pushback, to be frank, at the time. The taboo was so strong. There was not really a possibility to speak by many activists, although there was, and this is important to say, that within a year, the Lawyers Committee on Human Rights is releasing a report entitled A Year of Loss. We saw also some authors, Karen Greenberg comes to mind, Mark Danner, a number of these activists put out information about that. But against that, you had a lot of rationalization of torture, no less by Harvard professors, a lot of sort of rationalization of the need to be nasty to get result. A lot of nonsense, which unfortunately created sort of a normalization of this kind of approach, which is a hawkish approach, and which was in fact historically an imperial moment. And that's how it must be understood fundamentally, not just a colonial in some cases, but an imperial moment in that sense. When everything is revealed about Abu Ghraib, so we had Bagram, Abu Ghraib, Guantanamo, of course, where all of this took place, and other prisons that remained unnamed. We had the 60 Minutes and the release of the whole, subsequently, Taguba reports. But it's important to say that in the fall of 2002, and Yelena, correct me, please, if I'm wrong, the ICRC is also sending warnings to the United States that they had encountered issues in Iraq about this. And so you had a sense of, which according to the Washington Post leaked report at the time, was a good 6 months before that. So it took that kind of indirect public shaming for the realization to come, but still, Iraq took place subsequent to that, and we had all the violations that continued. The militias in Iraq engaged into this. We saw sort of a globalization of this moment, which was replicated in prisons in Egypt and in Tunisia before the Arab Spring, all over the world. This is a global moment by then. This is important not to just focus on the United States. And as I said, the global war on terror, for all of its sort of generic name, remain a global war on radical Islam. The FARC were not necessarily too concerned by it, for instance, as a terrorist entity, and named one, for that matter, or ETA, which closed business technically in 2013, etc. So there was clearly kind of a casting underneath that. And this led to the fundamentals of this, sort of the racialization of that, sort of the instrumentalization indirectly of what would lead ultimately in 2017 to the Muslim ban. And this is very important to be aware that these dimensions were there up in the air during all of this time, as it is the serious violations. Moving on to the last point, and we can discuss extensively. For those interested, the Theory of ISIS book that I wrote in 2017 has a whole chapter documenting that. Some of the dimensions of Abu Ghraib, for instance, remained unreported as of now, including very serious allegations of violations against children, for instance, according to one ABC News report. That's ABC Australia, not the US. So that whole kind of sort of nastiness was normalized in many ways. Of course, it led subsequently to changes. The CIA did release a report of some 500 plus pages, and there was kind of an awakening of sort in the United States with the Obama administration. But other techniques were introduced and normalized. The drone technique, for instance, which kept this very clean and elegant, quote unquote, and distant, more importantly, and therefore palatable to many, was used more by the Obama administration, in fact, than the Bush administration. And that's important to be aware of that. I didn't mention Yemen, where one of the first drone attacks was conducted in 2002. So it was sort of a global mapping, a global embracing of this, and therefore normalization. With the most recent phase, the net result of all of this is that we have now the long shadow of all of that has created a global situation in which the securitization, and particularly, of course, all of the sort of the boxing of the humanitarian organizations and the human rights ones, has led to a mainstream acceptance of this in too many quarters. And of course, a pushback by a lot of people, but there has been kind of a rationalization in the name of national security. This is due to the very basic technique of securitization, which is simply the speech act, as is known in scholarly work, which is by naming something a security threat, that it becomes one. Whether it is or not remains a matter of interpretation, and that is also becoming problematic for the question of law. I didn't hear, but I'm sure my colleagues would have mentioned anyway, the whole concept of preemptive action, which also was very controversial in many ways in terms of the legal dimension of it, to take action because this might happen. Following a political statement, we have to attack them there so that they don't come here, says President Bush, and echoed by his administration, and something understood in other places. I didn't mention the Aznars of Spain or the Sarkozys of France or the Berlusconis of Italy. So you have all of this sort of global dimension to this. I think what has happened with that is that this set the stage for a securitization of the state-society interface. And we saw a lot of that with COVID. We saw a lot of these patterning of the relationships in which sort of the privacy violations, sort of the acceptance, the ready acceptance of all of this has enabled a certain kind of securitization writ large, just about everything. And that, and the point was mentioned by my colleagues, is also forcing or accompanied, for me, the question of publicity is quite important, by agencies that have to simply say, well, there's a ban and you can't get on the plane, or there's a banking kind of regulations and we have to implement it, or you, humanitarian organization, have to abide by X, Y, and Z. And of course, there's a very, as an entity that has to function, it's very complex, but the pushback is really not there all the time because of the strength and the very sort of the muscularity of this whole dispositif, as it is called in the securitization 2.0 literature. But fundamentally, the sort of the patterning and the deepening and the recurring nature of this has led to this moment, which was normalized as such. I think I'm going to close there. I would simply want to say that I think the regulations are now essentially sort of at a moment where they have been accepted widely, as I said, but there's also accompanying the 2010s decade of sort of uprisings from the Arab Spring all the way to BLM by way of the Yellow Vests and all Podemos and all kind of other movements around the world. There's also a sort of an awakening societally, just as we had in earlier decades, the 70s, the 60s come to mind, where there's an important conversation to be had, lest we move into the 1930s redux and don't blame the messenger. I think historically these things tend to recur far more in an easier manner than we tend to think. And I'll leave it at that. Mohamed, over to you. Thank you for your attention.
Thank you so much, Mahmoud. That was incredibly helpful to kind of remind us of the historical context for many of these developments and the way in which certain regions and populations have over time been painted into this sort of exclusionary framework. So we do have a couple of questions in the chat. We have about 10 minutes. So I'm going to weave the question we have in the chat with one of my own, and we might be able to take one more if there are others who would like to add. But, you know, one of the things about the humanitarian principles, and particularly something like the principle of impartiality, is the idea that, you know, although they are imperfectly applied, we should constantly strive to apply them as best we can in humanitarian operations. So with that in mind, and this is a question for all of you, you know, what more could we be doing in the humanitarian sector from our various vantage points to, you know, push back, as Mahmoud has said, against some of this framing, against some of these constraints. And Yelena, you talked about the 20-year window for some of these positive developments to come about around, you know, the exceptions now for humanitarian aid. But could we do something that is slightly more immediate in terms of challenging this framework? And our questioner in the Q&A box adds that, you know, we are in a context right now where states seem to be denying humanitarian access with impunity. If you look at Ethiopia, Syria, and other places, and Yelena, you talked about consent as being integral to humanitarian action. And so I wondered if you could reflect a little bit also on how this shifting global developments, including the war in Ukraine and some of these more recent, rather audacious challenges to humanitarian access, how that will play out when it comes to reaching some of these populations. So two sort of related questions there. Who would like to go first? Yelena, would you like to go first? Okay.
Thank you, Monette, and thank you for the questions to Samuel as well. I can see it in the chat box. Very briefly, because we're out of, to be honest with you, I'm not sure. I think we have humanitarian organizations have made a push, and which enabled, and as Emma said, reality also enabled the reversal of some of the constraints on humanitarian operations. I have no idea how we could stop the general securitization of the world. I do not know. Personally, possibly, I think far more of there are two things. Far more impact should be given to human rights and IHL in the work of the United Nations, the United Nations, I don't mean states, thinking about the CT, Counterterrorism, Executive Directorate, and other bodies that have been created. They have been fairly unwilling to accept engagement with, human rights organizations, and to a lesser extent IHL. I think the push should be there because that architecture is incredibly important. And the second thing just flew from my mind, so I'm sorry. I will just have to end it there. With respect to Samuel's question, look, I don't think, in fact, that I don't think the current global developments are influencing the erosion of IHL. When people say the erosion of IHL, I always want to jump because the body of law is there. We're not talking about the body of law, we're talking about its implementation. And that is really important to know. So the focus should be not on changing the law, which I think in Ukraine as well, in that war has proven to be perfectly adapted, or very well adapted, given that it's an international armed conflict and the totality of the Geneva Conventions and Additional Protocol 1 apply. It's really a question of compliance. And given the multilateral moment we live in, my personal sense, is that both, particularly human rights NGOs, civil society organizations, must work at the very local level in order to, in fact, try and ameliorate respect for IHL if and when an armed conflict breaks out. I don't see any other way. We have the International Criminal Court. We really have, that's criminal responsibility after the fact. IHL needs to be implemented during hostilities. That is the main issue. And it's really trying to work at the domestic level, preparing states, society, and organizations to disseminate and for everyone to be aware of the importance of following the law. Right. So that's my sort of slightly confused response.
Very helpful. Emma, you get 2 minutes.
Thank you, Monette. Briefly to the question of, how can we sort of speed up the timeline a little bit? I'm unfortunately not sure it's possible. Policy change takes a long time, particularly when you have very powerful actors in place who actively do not want it. And I think we've made huge progress as a community, more than we actually would have expected, particularly when you look at global dynamics. Amazing that the US and Ireland, as pen holders for Resolution 2664, were able to get this through the Council the same year that we saw, what we did in Ukraine. That is an achievement. Yes. And now the focus really has to be on implementation. Ukraine more broadly on that question has, of course, changed the game really when we look at something like sanctions. We saw, of course, a massive proliferation of sanctions in relation to that conflict. And we now have a lot of actors who weren't particularly engaged in the question of hardening sanctions policy, more engaged on that question, which is of course changing dynamics a little bit for those of us who are advocating for the protection of humanitarian space within the creation of sanctions. Previously, we were really dealing with, a couple of high-profile states. It would have been the US and France, particularly, who were focused on the creation of loopholes when we were introducing humanitarian exemptions. In the US, for now, things are a little bit different. We still have France very strong on this issue, and of course, they have support as well. So that question of creation of loopholes, we're blue in the face from talking about it, but it still remains a concern for some states. And finally, just on the question of denial of access. Here we have to acknowledge, as humanitarian actors, we have very limited leverage, and we are increasingly finding ourselves in situations where we are at the very front line of engagements with actors with whom states are not willing to engage with directly on broader questions. Afghanistan is an example here. Humanitarian actors are there. We're trying to deliver assistance. We are doing so in many cases. And we have many states who are refusing to engage with the de facto authorities. And that of course is, that's their prerogative. But of course, it then has a knock-on effect on how willing the authorities are willing to engage and to provide access. We really need member states to be much more engaged and forward-leaning in some of these discussions. Thanks.
Mahmoud, for you, the final word.
Thank you. And I'll simply just maybe address the question raised by Brianna that I see in the Q&A. So in answer to the question about whether humanitarians do more harm or good in some places where they are allowed, or should they be allowed? Well, on that, I think as long as their consent, and Yelena reminded the importance of that, I think the desire to help is perfectly fine, and there's no issues. It's all more in the way this is playing out. However, I think that humanitarians and human rights activists really need a paradigm shift fundamentally. And I haven't seen in all these years sort of a deep self-examination of this. It remains very, very much more so on the side of the human rights crowd, as a matter of fact, more so of a sort of a tactical repositioning. Jessica White has a very interesting book 2-3 years ago about the rise of the most recent human rights wave in the 1970s in simultaneously historically with neoliberalism. And there's a very interesting set of remarks she unearths there. I highly suggest it. What I mean by that is then these are coded words. We and the humanitarian tends to be fundamentally, essentially a top-down, a north-south sense of a mission, which echoes all of these elements. It's known by everyone, and everyone gets a little bit defensive in the Western world whenever that is mentioned, just as whenever the racism question is raised. But that's besides the point. We're talking about scientific, historical issues, not ideological or political ones. And the more that is evaded, circumvented, rationalized, couched in nice words, the more this is not happening. There's a very sophisticated generation of humanitarians in the global South, another problematic term for that matter. And when you look at how the power relations that are taking place, you realize how much of this is still very much stuck in that mode. So to that, yes, of course, help, fantastic and welcomed and neatly within the IHL box. And I fundamentally agree with that. But equally, fundamentally, a need to really kind of have that paradigm shift, and not just as a discussion, because power would block and not move into that. But I think that probably may be where this generation can push in engineering that momentum. And I do see the glass half full on that, as I said, in spite of all the violations that we see. And many of these organizations have started making some space for those conversations to happen. And I've engaged with a vast number of them. And there's quite a lot of, I think, goodwill. But unless there is political leadership or simply good leadership within these institutions and defiance of those problematic policies, which simply remain policies to be tackled, I think we will fall back again on the securitization, rationalization that I named earlier. Thank you very much.
Thank you, Mahmoud, and thank you to all of our panelists. I knew we were in for a thought-provoking, insightful set of remarks today, but you have really helped us push the envelope and understand these issues better. So I thank you all for your engagement with the audience as best we could, and for sharing your thoughts today. And thank you to our audience members, and also to my team and the team at the Amman Global Center for helping us pull this together. But a final big thank you to our panelists today. Thank you all, and see you on November 9th for our final panel of the series. Bye all.